Welcome to Books of Our Time, produced by the Massachusetts School of Law and seen nationwide. Today we shall discuss a book by Charlie Savage, the Boston Globe reporter who won a Pulitzer Prize for his reporting on George Bush's use of signing statements. Charlie has vastly expanded his work on executive power for a new book that details the entire gamut of ways that the executive branch has attempted in the last 6 years to extensively destroy the independent authority of Congress and the courts, thus creating, in my personal judgment, by far the gravest constitutional crisis since Vietnam and Watergate. Charlie's new book is called Takeover. Its subtitle, appropriately enough, is The Return of the Imperial Presidency and the Subversion of American Democracy. I believe this book will be the Bible about what has happened until historians begin to fully plumb the actions of today's executive branch 10 or 20 years from now, when memoirs and papers and other such historical materials are more fully available. And while one never knows about these things, my view nonetheless is that Charlie ought to win another Pulitzer for Takeover. It is a great contribution to knowledge of what happens in American government. Charlie Savage is with me today to discuss his book, and I am Lawrence R. Velvel, the Dean of the Massachusetts School of Law. Charlie, to take up where we left off at the end of the last hour, the Supreme Court has decided 2 cases involving Guantanamo. There is a third case up there now. Has the Supreme Court accomplished anything in its first 2 cases?
Well, the first case was in 2004 when the court held, as I mentioned in the last hour, that despite the administration's legal theories, it did have jurisdiction to hear claims arising out of Guantanamo. And that unleashed a torrent of litigation, of habeas corpus petitions on behalf of hundreds and hundreds of detainees who wanted to have some judge review the basis of their detention. Are they really who the executive branch says they are? Are they really Al-Qaeda? Were they just in the wrong place in the wrong time? Are they really Taliban? Or were they just sold for the bounties we were collecting from local tribes that just wanted the $5 grand a head and they shouldn't be in prison anymore? So very few people got released as a result of that. No one, in fact, has gotten a hearing. But it did allow some attorneys to go down and to meet with these detainees and to hear what they had to say and then to relay some of those things after they were cleared to the public. And so it kind of cracked open a little bit of the secrecy of what was happening at that prison. We started learning about things like hunger strikes and suicide attempts and so forth. In 2006, one of those claims that was not a habeas corpus petition, but was actually a challenge to the military commissions, which were finally starting to get underway down there, resulted in the Supreme Court striking down Bush's claim that he could put on military commissions in defiance of a certain statute passed by Congress, or in a different way than the statute said these things had to work, and as a side effect also that he didn't need to obey the Geneva Conventions. And that case, which is called the Hamdan decision, was the single greatest setback to the Bush administration's efforts to expand executive power, because they had avoided having a definitive repudiation of their rather aggressive theories for years. They'd sort of claimed this. People said, hey, you can't do that, but there was no forum in which they were definitively repudiated, and so they were taking actions based on these claims, and the actions were setting historical precedents which seemed to shore up their theories. Something, yes, it can be done because, look, we just did it, so that was doable. But in the Hamdan case, the Supreme Court said, no, you've got to obey a law passed by Congress, and you've got to obey the Geneva Conventions, at least Common Article 3, which guarantee fair trials. And so that was a big deal. And it was sort of, for the people who are critics of the Bush administration's legal theories, it was sort of hailed as, well, now normalcy has returned. It's been shown that they're wrong, and as we thought. But I think that some factors about that celebration have been short-sighted. One of them is that because of one-party rule in Congress, the administration was very quickly able to roll back that decision on a specific grounds by, in fact, Congress has set military commissions back up for them. But more importantly, Congress, in that same law, the Military Commissions Act, made sure that the decision would never spread, that precedent could not be used to attack any of the other things the administration was doing, so that it was be narrowed. They took away, at that point, the habeas corpus rights of detainees, so there could be no more lawsuits, and they took away separately the jurisdiction of the courts to hear lawsuits that invoked the Geneva Conventions. And so that meant that no one could ever in the future say, hey, wait a minute, you're violating the Geneva Conventions. Essentially, the president could interpret them for himself and into meaninglessness.
Didn't they also, do I recollect correctly, that they also said that the military commissions can use secret evidence or evidence obtained through coercion if the judge at the tribunal believes that the evidence is
reliable.
Reliable.
There were two fights. The Bush administration wanted to be able to use hearsay evidence and evidence obtained from coercion, and it also wanted to be able to use secret evidence, evidence that the defendant would not be exposed to. He could be sort of excluded from his own trial and convicted on the basis of factual assertions that he would never have a chance to rebut because he wouldn't know what they were.
Right.
And Congress, on that latter step, did reject what the administration wanted and said no secret evidence. But on the former controversy, they accepted the administration's arguments and said that coercive evidence obtained through coercion could be admitted on a case-by-case basis, subject to the judge's decision.
It is my understanding, Charlie, correct us if it's wrong, that the case that's currently in the Supreme Court now, which it took semi-belatedly, I gather, in certain peculiar ways, involves the question whether it's constitutional to remove habeas corpus jurisdiction. And part of that question revolves around whether some alternative methodology of decision-making is provided for, an alternative satisfactory methodology is provided for. And curiously enough, if I just read the brief filed by Arlen Specter, of all people, saying that it's impermissible to take away habeas corpus jurisdiction and talking a lot about why the procedures are not sufficient down in Guantanamo. He sort of was one of the people responsible for ramming the whole bill through the Congress in the first place, and here he is attacking it, an important part of it, in the Supreme Court. That's background to my question. The question is, do you, and I know this involves speculation, which you don't like to do, but based on what you've said in your book, let me put it that way. I'll make a statement. You can tell me if this statement is really too far off base. I think that given the fact that, that George Bush has put Sam Alito and John Roberts on the court, and that they spent considerable time in their younger years in the Reagan administration trying to find ways to extend extensively presidential power. Alito was on a special litigation working group. Roberts wrote some memoranda, and some other things happened when they were up for the Supreme Court, which I can get into later. But I think personally there's no chance, or virtually no chance, I will say no chance, that the Supreme Court is going to strike down what Congress did in 2006 or 2007, whenever it was, with these two gentlemen now on the court. Alito voted with the executive the last time. Roberts had to disqualify himself because the opinion being appealed from was one in which he had participated as a Court of Appeals judge. But anyhow, there's my background statement. What do you think about all that?
Well, part of this folds out from what we were discussing just a minute ago. I think another way in which the Hamdan decision has been overhailed by people who are critics of the administration's legal theory is that they fail to appreciate that only 5 of the 9 justices disagreed with the White House in that military commissions case. And the other 4, Alito, Thomas, Scalia at the Supreme Court level, and John Roberts had already done so, as you just said, at the appeals court level, had in fact embraced the theory that the president didn't need to worry about a statute from Congress or the Geneva Conventions in this sort of national security area. And crucially, the 4 are more than 12 years younger on average than the 5. And so I think that if not this president, an election cycle 2 or 2 from now, there's going to be a very good chance that if another president wants to expand his institution's powers, a 5th presidentialist lawyer may very well become a 5th Supreme Court justice. And at that point, the law shifts.
Yeah.
They're right.
Yeah.
Because the Supreme Court, 5 justices on the Supreme Court say something is the law, it is the law. So that's...
We're not right because, how did Jackson say it? We are not final because we're right. We are right because we are final.
Yeah. No.
Yeah.
So moving into this question, though, I don't know that you're right, I'm not going to speculate too far on what the court's going to do, but I can tell you and the listeners what this sort of discussion surrounding this fact is. Originally, the Supreme Court declined to hear the case. And to hear the case, it needed, 4 Supreme Court justices to grant cert. And so, so that means there was 5 justices. But then they went back and they revisited that decision, and they decided they were going to hear cert after all. And to revisit a decision like that means that you have to have 5 justices who are willing to do it. And I think the speculation is that that means that the 4 liberal justices and Kennedy, now probably providing that 5th vote, suddenly want to hear this case after all, want to revisit whether or not the jurisdiction can be stripped for the detainees, because at the appeals court level said, sorry, these cases are all thrown out. And so the fact that they did that, which means 5 justices want to revisit that decision, suggests that it's possible that Kennedy will join liberals and not the conservatives on this case, and say that there is still jurisdiction to hear some kind of lawsuits coming out of Gitmo.
Yep. I have to say, Charlie, one almost hates to make judgments based on the very day that something occurred, because that's often, even usually, turns out to be wrong. Although something like this very similar happened when the New York Times broke the story about the spying, and suddenly certain judicial minds appear to have changed. Today's New York Times article, I think, is ultimately going to have, no, let me rephrase that, may well have a significant impact on what the court does, because this is really quite the thing. You know,
you've referenced this a lot in the last hour. I don't think you ever explained what it is. So what happened in the New York Times today is it says that there are some new legal opinions that are still secret. It's unclear whether the Times reporters have even seen them themselves. So all of this is with that grain of salt. But that seem to indicate that they are still asserting that the president, as commander-in-chief, et cetera, has the power to authorize harsh interrogation techniques, which was an opinion that first came out, as we talked about last hour, at the very end of the last hour on August 1st, 2002. It leaked to the public after Abu Ghraib, and Jack Goldsmith, the new guy at OLC, rescinded the memo and had it replaced with one that was more mainstream. Yeah. And it appears that there's now a new replacement memo that's been kept secret that sort of backs harsh techniques again. But we haven't seen it, and it hasn't leaked, and it doesn't seem to me that the reporters have seen it either. They've just talked to people who've seen it. So,
well, let's turn to that then just for a moment before I talk. I ask you about some other things. You see, Charlie, there, and I know you know this, but I'll say this for the audience's sake. On August 1st, 2002, not one but 2 memos were sent forward. One was what I would call the generalized U memo, which subsequently got replaced. Another was a wholly separate memo, which has been secret to this day, not a generalized memo, but a memo talking about the specific practices that were being used by the CIA and approving those specific practices. And that happened again with exactly the same kind of dichotomy. Happened again in half a year later with the Department of Defense. And apparently, according to the Times now, there are new memos discussing the exact practices and approving of the exact practices. Very specific. Now, the exact practices include waterboarding. And anybody who knows it, well, let me say that an Argentinian torturer who used waterboarding has said that's worse than pain. That cannot be withstood because you're making somebody feel that they're drowning. And it includes all kinds of other things. And the CIA, according to this article, was very concerned, the interrogators, that, well, maybe one technique by itself is okay, but what if you do them all together? And this one fellow, I forget whether Zubaydah or Sheikh Mohammed, it is said they did it to him 100 times in 14 days. Nobody's going to withstand that. I think that's what this all is meaning, that there was a reaffirmation and there were specific opinions saying you can do all these things. They are not forbidden. They are not torture. And indeed, you point out what McCain's law said, about coercion and so forth. And it came out today that this fellow who went to my law school, sorry to say, said that will not violate, before the law was passed, he said that stuff will not violate McCain's law against coercive activities. And that's the stuff, waterboarding and the whole gamut of it. That's what this article is really all about. And that's why I think this article is going to have an impact on the Supreme Court. Now, that's just my opinion. That's just my opinion. Okay, now, you discuss extensively the process by which the White House vetted Supreme Court justices, including John Roberts. And you say that eyebrows went up when it was revealed because Roberts had put it on a questionnaire after being nominated for the justiceship, chief justiceship. Well, I don't know, he was nominated for one and then he went to the other, I guess. That he had talked to Cheney. And you reveal in the book, and I think this, I had not known this, and I think this is a major revelation, disclosure in the book, that Roberts spoke with not just Cheney, but also in the room were Addington, Gonzalez, Myers, Karl Rove, and I've forgotten who the sixth one was. And I find it inconceivable, Charlie. And I base this both on common sense and knowledge of what these people were doing and what's in Jack Goldsmith's own book about the interview that he had with a couple of these guys. I find it personally inconceivable that Roberts did not give them assurances, not necessarily of what he would do on a particular case, although he was sitting on the Guantanamo case at that very time. But he let it be known, hey, my heart's with you all the way, don't worry about anything, you know, something on that order. You have any sense beyond what you said in the book of what those discussions might have entailed?
I mean, you're speculating hard there that he would have said something like that. I don't think that he needed to say anything like that, and he's a very careful man, so I doubt he did. I mean, but you're right. What was interesting about what was happening was that was the moment he was sitting on the Hamdan case at the appeals court level, that he was hearing it, that he was discussing it with his colleagues, and then handing down the decision approving this presidential power just a few hours before Bush, in fact, decides to pick him for the Supreme Court. So, I mean, that actions speak louder than words. I find it highly doubtful that he said, here's how I will rule in specific cases.
Oh, I don't think he said that. I think, Charlie, that between gentlemen, as they used to say back in the old days, explicitness is not needed. Or to say, yes, I agree strongly that the president has extensive powers to fight on behalf of terrorists, on behalf of national security, because after all, the future of the nation is threatened.
But you know, beyond this, it's, you know, he didn't need to say anything because the records were there. They were going through the stuff that subsequently the rest of us could go through at the National Archives, which were still sealed at that point from the Reagan administration. They could go through his files and the memos he was sending back in the 80s. And so I have a whole chapter in the book about Roberts, Alito, and Harriet Miers, the failed nominee, and sort of saying, when all three of these nominees were put forward for the two Supreme Court vacancies, almost all of the discussion was about social issues. Are they going to rule against abortion rights and affirmative action and environmental protections and things like that? And that kind of swallowed up the conversation. And I think that obscured something very significant about all three of those nominations, and that is that all three of these nominees were presidential lawyers. They had each spent years working inside a White House, or in Alito's case, the Justice Department, on issues directly related to expanding executive power. They had taken positions that were even stronger than their own colleagues inside of Republican administrations in certain cases, but they'd been marinating in these disputes from the point of view of the White House. And that meant that they were going to bring to the bench a great interpretation of sort of maximal presidential power, of deferring to the executive. In the Guantanamo case this year, maybe, but who knows what it'll be 5 or 10 years ago, 10 years from now, where the White House is making some claim of power. They are more likely to side with the White House. And you know, there was a huge range of very prominent, very qualified, very conservative lawyers, academics, lower court judges from whom the administration could have chosen. I just think it's very telling that each time they went to this very narrow slice of the conservative legal universe, which is executive branch legal warriors, 3 out of 3. And so that I think that is a part of the groundwork that they've been, an integral part of the groundwork that they were laying on many different tactical fronts for a long-term expansion of executive power.
Well, your chapter is extremely impressive on this, which is not to say the rest of the book isn't. It's just this is a particularly impressive chapter. And I would have to say, Charlie, that you point out, and Jack Goldsmith points out, that people who had played ball with the administration for a long time, both in the executive branch and in the judiciary, like Michael Luttig, who left the Court of Appeals of the Fourth Circuit to become, I think, general counsel of Boeing once it became clear that because of something he did, he would not be nominated to the Supreme Court. And then there would be Philbin and Daniel Levin, and there were a few other people. You didn't cross what Addington and Cheney wanted, or your chances of promotion were finished. And, you know, I'm sure that Roberts believed everything that he wrote, but he couldn't be blind, in my judgment, to the notion that had he come down the other way in that Guantanamo case, goodbye Supreme Court.
Well, probably, but again, you can go too far in that direction, because when you look back at his record through the 80s, this is the position he's been taking his whole life.
Yeah.
I don't think that would be more remarkable if he suddenly went 180 degrees from the opposite point of view.
Yeah.
And they would be foolish to pick him if that's their strategy then, because as soon as he's on the court, then he'll go back to the way he was before.
Yeah.
This is his philosophy for real.
Yeah, well, agreed with all of that. Charlie, another really fascinating part of the book is where you disclose something that is, I've never seen it anywhere else. Today in the paper, the Times pointed out that right after 9/11, the CIA, according to what the newspaper said, consulted with the Egyptians, and I think it was the Syrians, but I'm not sure about that. It was the Egyptians and somebody else, about what kind of interrogation methods work. Well, if that's true, that says it all right there. But you point out that the methods we used, I mean, this is really fantastic, were originally taken from what the North Koreans and the Communist Chinese did to break our soldiers who were their prisoners, to get them to admit to things which simply weren't true. And you know, those of us of a certain age are familiar with movies of guys getting up there and saying, I did this and I did that, and the United States did this, that, and the other. It was all untrue. And that they did, this was brought to pass by these methods used by the North Korean and the Chinese communists. And then others picked them up, and we used them not for the purpose of getting these people from Al-Qaeda and other terrorists to say things that weren't true, but to get them to say the things that we thought were true, which comes, another way to say that might be to say what we thought was true and what we wanted them to say. And then people got surprised because the things they admitted to were lies, because nobody can withstand this sort of stuff, viz. Our prisoners in the Korean War. You say only a few people even, well, how did you find out about this? And who was it that remembered this very crucial piece of history?
All right, so I'll start at the beginning. In the Korean War, we had a problem that we had not encountered before in any previous war, and that is that we were having pilots that were shot down in over North Korea, and they were suddenly appearing on film that were being released by the communists, confessing to war crimes. They were saying, I was sent to spread, chemical and biological weapons among civilian populations because I am part of the evil United States regime. And these guys did not appear to have been tortured. They looked perfectly fine, but they were just sort of saying these things that were wildly false, and that we knew were false because we weren't, in fact, dumping biological weapons on civilian populations. But they were, it was propaganda film. So after the war armistice, and we got these guys back, we debriefed them. What happened? Why did you say these things? And it turned out that they had been broken through this sort of communist brainwashing technique. That's actually, I think it really dates back to the show trials under Stalin in the 30s, where people would confess to being American agents and so forth, and then sent off to Siberia summarily. Then spread to China, and the Chinese in the North Korean POW camps were doing this to our soldiers. And it was things like prolonged sleep deprivation, stripping people naked, messing with the time of day they thought it was by changing the light conditions and when their meals were showing up at really arbitrary times, frightening them with all kinds of things, but that left no scars, bombarding them with very loud music and grating sounds, putting them in severe heat, severe cold, all of these things on top of each other until basically they lost touch with reality because their internal resistance to resist broke down. They had what's called learned helplessness, and they were debilitated, and they became dependent upon their interrogators and were willing to do whatever their interrogators wanted them to do, which was confess to these false propaganda things that they could use for political purposes. And so this knowledge kind of had some impact. The famous movie, The Manchurian Candidate, it's sort of how it manifested in popular culture. Everyone was suddenly interested in communist brainwashing. But inside the military, it led to the creation of a school under Eisenhower, called Survive, Evade, Resist, Escape. SEER school. And the motto of the school was Return with Honor. And the idea was we are going to train our pilots and our dudes that work behind enemy lines who are at risk of capture so that they can resist this stuff and they will not produce these propaganda tapes anymore. And so at SEER school, which over the next 50 years became sort of institutionalized, our troops are subjected to things like being stripped naked and light and cold and heat and loud noises and all this stuff. But over the next 50 years, this insight. Okay. Well, actually, So after 9/11, before 9/11, we did not have a widespread interrogation program. We just weren't doing a lot of interrogations. And after 9/11, suddenly we had this huge need to interrogate hundreds or even thousands of detainees that may or may not be Al-Qaeda, may or may not know something. And we didn't have a huge cadre of people who are qualified to do it. And what happened was that people who had been through SEER school, or even SEER instructors themselves, got kind of enlisted to be real interrogators and to reverse engineer these techniques that we were just putting our own soldiers through, but to put our prisoners through them, to see whether we can break them, and they'll tell us what we want to know, which is when's the next 9/11, who is it, where are they, let's get them. But a critical insight had been lost, which was over the 50 years, the idea that was not to get reliable, accurate, real, actionable intelligence that relates to the real world. It was to break people so they'll say whatever it is you want them to hear. And in fact, the CIA also studied some of this stuff in the 60s, and they wrote a manual which later became public that talks about it. And it says this stuff is really a dangerous thing to play with, because when you break them enough that they enter this state of learned helplessness, they've also lost touch with reality at that point. That's the whole point. And so they don't know what's real and what's not real, and they'll just tell you whatever it is they think you want to hear because they want to please their interrogator at that point. And so there's a few real interrogators in the government who know how to extract information, and they are professional, trained people who do this for a living, and they were totally aghast that this is what was happening. But this is the kind of behavior that the Bush administration approved after 9/11, and it's all over the place. We saw it, in Bagram Air Force Base, in Guantanamo, even on U.S. soil. When Jose Padilla's lawyers say that this stuff was done to him as well, because they thought, but this is crazy. We're going to get them to say anything, and so and in fact, we know that that's what happened. That a lot of the orange alerts where it's, now they're after shopping malls, now they're after banks. That was, are you guys going to attack shopping malls? Yes, and that's where it came from, right? And probably most critically. Here's a bunch of pictures. These guys are Al-Qaeda. Yes, yes. And then now these guys get stuck at Guantanamo because someone pointed to them and was asked to point at them. And if that's all there is, it's dubious. And we know that one of the worst manifestations of this was at Colin Powell's presentation before the United Nations Security Council about how Iraq was conspiring with Al-Qaeda to put WMD in terrorist hands. Powell talks about how we've got one of their operatives, and fortunately we captured him, and he's told us what he knows, and he knows about the mobile labs and this and that and the other thing. It was all stuff that had been produced through one of these interrogations. And then later on, the CIA determined that, in fact, this guy had no knowledge of this stuff that he had told them about, that he was just telling them about Iraq working with al-Qaeda because that's what his interrogators wanted to hear. And they cleared it, but, you know, by then the presentation had been made, and we were in
Was that Abu Zubaydah?
That was not Abu Zubaydah. That was another guy.
Khalid Sheikh Mohammed?
That was not Khalid Sheikh Mohammed.
I've run out of names. Okay. Yeah. All right. Okay. Major point being you lose touch with reality, and so you say whatever the interrogator wants to hear because you want this horror to stop. Period. Charlie, you made your name with signing statements, if I may put it that way. That's what made you famous around the country. Before that, you were only a very good reporter. But with signing statements, you became known around the country. Why don't you tell us what the signing statements are, what was achieved by them, and how they altered the constitutional process?
Okay. So a signing statement is an official legal document that a president issues on the day he signs a bill into law. He files it in the Federal Register, and it consists of instructions to the executive branch about how they are to implement the new statutes created by a bill now that they're on the books. And where this becomes controversial is where a president uses a signing statement to instruct the executive branch that it will consider certain sections of this bill unconstitutional, so that they do not need to enforce the law as it is written. And it becomes very controversial is when those sections that he's challenging are restrictions on his own authority, because then not enforcing the law really means not having to obey the law. And previous presidents have done this, but it was exceedingly rare until the mid-1980s, when the Reagan administration legal team decided they could start doing this more often as a way to increase presidential power. Sam Alito was part of that effort.
Well, explain why they thought the courts might look at this as sort of legislative history.
So the original idea was that activist courts were interpreting laws based on legislative history, that is the record of debate that Congress had when they were passing a law to sort of figure out what a law meant, and the judges were sort of picking and choosing what they wanted from that universe to support whatever their preferred policy version is.
Which is probably true, by the way, but anyway.
It's definitely it's one of Scalia's great crusades. He hates this stuff because it's so open to manipulation. Yeah. But as long as this is happening, we should at least get the president's views in there. So maybe when there's an ambiguous statute, the president should leave a record of his understanding of what it means, and if there's a dispute later, the court will look to that, and the president will have greater influence as the sort of final word over what the law will be interpreted to mean. And that turns out that never happened. Courts really just haven't looked at signing statements. But this tool became powerful in this other way of shaping how the executive branch was going to implement laws, and even not implementing those the president thought were unconstitutional. And so George H.W. Bush issued a bunch. Bill Clinton, a Democrat, also issued a bunch. But then the Bush-Cheney administration took this to a whole new exponential leap. And at this point, the count is over 1,000 bill sections, 1,000 laws that just in 6 years Bush challenged using signing statements, which is more than all previous presidents in American history combined. So this is dramatic. Even with the increase starting in the Reagan years, it is almost double all previous presidents in history combined. And it includes the McCain torture ban, which this is unconstitutional because of my unwritten powers as commander-in-chief and because of the unitary executive theory. Oversight provisions that were added to the Patriot Act by Congress as a condition of making that law permanent. But also things that have nothing to do with national security. All kinds of affirmative action regulations, requirements to give reports to Congress about all kinds of things, just all over the map. Anything that requires the executive branch to do something or forbids it from doing something under the Bush legal theories is unconstitutional because the president has total control over government information, over the executive power, and so forth.
It's a unitary theory, more or less.
But that is one of the major theories that is cited in these things. Yeah. The affirmative action regulations is more that his theory that that violates, individual rights and so forth. So this has been this totally new thing, and as this started to come to light, some argued that it explained why Bush was not vetoing anything. It took him 6 years to veto his first bill, and where he's being so aggressive about exercising his executive prerogatives in every other respect. It was this big mystery. Why has he vetoed nothing? Other presidents that have had one-party rule have still vetoed things from time to time. And the insight was, well, maybe these things are functioning kind of like something close to a line item veto. You sort of pick and choose in the bill what he wants and what he doesn't want. And an override-proof one at that, because there's no mechanism for Congress to say, well, we disagree with you, the way there is with a real constitutional veto. And so it was kind of a loophole in the Constitution. The executive branch enforces the law, but that means it has to enforce the law against itself, and if it chooses not to, no one else is able to do it, right? It's the old problem of free societies, who polices the police?
Right.
Who rules the ruler? Right. And that executive branches, one after another, have been gradually prying open for the last 20 years, and now the doors have been blown off, essentially. There's some dispute over exactly what the nature of the problem is. Some people think, the American Bar Association thinks that signing statements are per se unconstitutional, that a president has only two choices. He can either sign a bill and then enforce or obey all of it, or he can veto the bill, but that's it. And an alternative position, which is mainly embraced by Clinton administration lawyers, is that no, signing statements can be okay as long as your constitutional theories are mainstream. If Congress passes a sloppy bill and there's a few provisions in it which are unconstitutional, but everyone agrees they're unconstitutional, it's okay for the president to sign that bill and not enforce those. And so there's a lot of just so the machinery of government keeps moving. And so there's a broad agreement that something is wrong. There's disagreement about precisely what the nature of that is. And people are still struggling, I think, to understand what to do about it. There's been some legislation floated, but it's all...
Back when I was younger, Charlie, which was decades ago, one of the theories or ideas used to be that if Congress had done something which is blatantly unconstitutional, in those days there were a lot of blatantly illegal bans against free speech, then what the president should do is he signs the overall bill, which includes this, and then he either brings a sort of a friendly lawsuit, as it were, against somebody who contests it and says this to the courts, this provision is illegal. Case, or else you wait for somebody to sue for an injunction, and then you confess error as part of the executive. You confess error, say, yeah, that's right, that guy's right, this is unconstitutional. So that's another possibility, I would suppose.
Well, it's interesting. Even though the Clinton administration was using signing statements more than any other previous Democratic president, they also were sort of inconsistent. There was a famous example in 1996 when Congress passed a large military appropriations bill. It had a provision on it that said all HIV-positive soldiers, even if they're healthy, have to be fired, have to be summarily drummed out. And Clinton's legal analysis of that was that's unconstitutional. But his legal teams, Walter Dellinger and Jack Quinn, said, we can't just not enforce this because a court hasn't yet definitively said it's unconstitutional, A, and B, by enforcing it, in fact, we will create the conditions for a lawsuit for this to get knocked down. And if someone then sues us, we're not even going to defend the law. We'll say, as you say, confess error or whatever. As it turned out, in that case, Congress rescinded it right away, so there was no. But that was the approach that they adopted to what you do with a situation like that when the president wanted to sign the bill rather than veto it.
Charlie, in this article in the Times today was something which confirmed an idea that had entered my mind after reading what you had said about the use of signing statements to shape what the bureaucracy does. And it had begun to occur to me that maybe one of the reasons, maybe the reason, why Bush attached a signing statement when he signed the McCain Anti-Torture Act was to let his people at the CIA know, hey, as Commander-in-Chief and head of the unitary, I've told you to do this, don't worry about this. That more or less, well, that was said in the Times today, but it's an example of something you talked about, which maybe you can elaborate a little further on, which is whatever its legal validity or invalidity, a signing statement is extremely effective in getting people in the bureaucracy to do what the president wants, because they're not about to risk their jobs, reputation, and livelihoods by disobeying what they know the president wants. Is there more? I mean, are there further examples of that that spring to mind?
Let me think about how to answer that. You know, one of the things as signing statements became really interesting last year, but they were always interesting as more and more people started paying attention to them. Obviously, there were a few political scholars who were paying attention to them all along, and they were very prescient. Was, well, what's actually happening? Is this just chest beating? I could do this if I want to, but he's not actually following through and not obeying these laws? Or is it, you know, in the most interesting ones were all involving national security, and there's no way for us to independently know what the, you know, is someone being tortured or not? I don't know. So this last year, the Government Accountability Office, at the request of the now Democratic Senate, did a study of 19 of the 1,100 laws that Bush's signing statement did, and they were sort of all different types. None of them had to do with national security, so there were sort of more tame examples. But just to begin to understand, when you peel back what's happening in the executive branch, are these being obeyed or not? And they found that 3 had not been triggered by circumstances, so the law, it's unclear whether the law, what happened, because the law never had to be enforced. Of the 16 that were, 10 were obeyed as written, despite the fact that Bush had challenged them, but 6 were not. And these are small things. Like there was a law that said in the Tucson sector, the immigration and police who look for illegal immigrants had to move their checkpoints every couple days because evidently they were getting lazy and sitting in one spot. Right. And illegal immigrants from Mexico were just sort of knowing to avoid that spot. And the local congressman was annoyed and passed this law saying, in my role as regulating the executive branch, in Congress's role, this has to be changed. And Bush put a signing statement on it that said, that law will be viewed as advisory only because I decide how to deploy troops and I decide how to deploy immigration agents. And the GAO found, in fact, they just sat there. They did not move around at all, as the law said they did. And they went there and they asked, how come you're not moving? And the answer was, well, this law is merely advisory. And it used the answer from the agency used the same language as the signing statement. So that was a strong sign that these things are, in fact, having an impact. There was another one just now that there was a law Congress passed that said, if you were born in Jerusalem and you become a U.S. citizen, your passport has to be stamped that you were born in Israel, which of course is a disputed issue. Is Jerusalem part of Israel or not? And Bush put a signing statement on it saying, I have exclusive control of foreign affairs, so the State Department will not enforce this law. And that was a rare case where someone actually had standing to sue. So someone who had been born in Jerusalem and wanted his passport to say Israel sued, and just last week, a federal judge threw the case out and said, this is a political question, and you guys have to decide it for yourself. And of course what that means is the executive branch wins because it has the first mover advantage. Right. It does something, and unless Congress is going to go to war, you know, and impeach the president, they win, and they're not going to impeach Bush over whether someone's passport says Israel or not. Right. And so they're real.
Yeah. You know, you make some very interesting points, Charlie. You've said already that this was like a line item veto, which had been denied to the president. It's also true that similar changes in the constitutional structure have been denied to Congress in the past. To wit, the famous Chadha versus INS case, I think, which was the one House veto and also a 2-House veto. Maybe Chadha was a 2-House veto, but just like the executive doesn't have a line item veto, the Congress doesn't have a 1 or 2 House veto. They've got to repeal the whole darn bill, and of course the repeal can be vetoed. So these are all part of the same kind of attempt to change the constitutional system, I take it.
Everyone tries to expand their powers. And actually, you know, that's an interesting case in defense of the executive branch in signing statements, because even though in 1983 the Supreme Court said legislative vetoes are unconstitutional, Congress, both chambers have to vote on something and present it to the president for it to have any lawful effect to be vetoed or signed. Congress has kept writing these things in the bills because they really would prefer that were not the law, that they could do this. And a number of the signing statements, a large number of them, are merely attacking legislative vetoes and saying this is unconstitutional, so executive branch agency don't in fact go to the Senate X committee to get permission before you do something because And so that's an example of maybe what the Clintonites were thinking about. Do we really have to veto every bill in which some congressman sneaks in some legislative veto? can't we just sort of wink and nod and life
Yeah.
goes on?
Yeah.
It's a totally different thing than I can torture whether or not Congress
Yeah.
says I can.
Yeah. Charlie, you point out several other ways in which the executive has, the administration, I guess I should say, has tried to exercise tremendous power, like ordering changes in reports on the environment or on drugs, ethical drugs, changes in the department, how you pick people for the Civil Rights Division of the Department of Justice. Why don't you talk a little bit about this? There's a significant part of a chapter in all of this in the book, and it's a very interesting chapter. Some of it has been in the papers before, but it brings together, as so much of your book does, in one place, a collection of the things that have been going on.
Right. Well, you just mentioned two different things.
Yes.
The first was altering reports to make them fit in line with administration agendas, be it about global warming or stem cell research or whatever. That would fit into, I think, the broader rubric of information control, preventing information from coming out of the bureaucracy that undercuts the White House's political agenda, whatever it is, rather than letting sort of the technocrats and the government scientists just sort of present their findings, whatever they may be.
Some of these guys have been leading scientists who had their papers altered.
Yes. So that's one thing. And those chapters are called secrecy, but it's really information control.
Yeah.
The other thing, the Civil Rights Division is just an interesting case about case study in centralizing greater control in the White House over executive agencies and the bureaucracy, the permanent government, which is just another sort of facet of this increasing the power of the White House, concentrating more power in the White House. In the case of the Civil Rights Division of the Justice Department, there is, of course, political overseers who change with each administration, but most of that division are several hundred career attorneys who stay there year after year, and their job is to enforce the nation's civil rights laws, to bring lawsuits, to settle cases, to find places where anti-discrimination laws are being violated, and step in. This agency has long been a thorn in the side of conservative presidents. Nixon tussled with them, Reagan tussled with them, but that's sort of to be expected. That's politics. One of the things that neither Nixon nor Reagan or Bush 1 did was change the procedures for how career bureaucrats in that agency are hired. And this is an unprecedented step that the Bush administration took. Previously, when there was a vacancy in their ranks, committees of other career attorneys would screen candidates and conduct interviews and decide who to hire. And the upper political appointees had to sign off on it, but they always accepted whoever the advice was. That changed in 2002 under Attorney General Ashcroft. Now the political appointees did all of that process themselves. And one of the things I did as a reporter was I obtained, with the Freedom of Information Act, all the resumes of people hired by the Civil Rights Division before and after that change. And what I found was that people who had prior experience in civil rights just plummeted, and people who had very conservative credentials, like membership in the Federalist Society and Republican National Lawyers Association, or had been working for groups that were attacking affirmative action programs or were defending corporations against discrimination lawsuits, were instead being hired now to enforce anti-discrimination laws. And the character of the agency was rapidly coming under political control by making sort of everyone a political appointee. And as this was happening, suddenly, instead of filing big lawsuits alleging systematic discrimination against African Americans or things that sort of were the bread and butter of that agency, they were suddenly filing unprecedented lawsuits alleging reverse discrimination against white people or discrimination against Christian groups and such. And that's how that agency's resources were being diverted into a way that the White House found more politically palatable. And so it's just another sort of very smart way in which they figured out a way to sort of seize greater control, impose greater political control over the executive branch.
Charlie, one of the groups of lawyers in the executive branch for whom I personally have a great respect are the military JAGs. And at the highest level of the four services JAGs, the Marines, the Navy, the Army, the Air Force, these people are extraordinarily competent people, and they had a lot of objection over the years to things that were being done, such as ridding ourselves of the Geneva Conventions. They think that's just an awful idea. Talk a little bit about what the Bush administration attempted to do to circumvent and to eliminate the influence of the military JAGs, Judge Advocate Generals.
Sure, this is another chunk of that executive branch chapter. Going back to the Bush-Quayle administration when Cheney was Secretary of Defense and Addington was his top aide, and Jim Haynes, who's now General Counsel of the Pentagon, was then the Army General Counsel. There have been repeated efforts to subordinate the JAGs, to impose greater political control over picking who gets to be a JAG, and to pass laws and regulations or internal orders that say that the JAGs cannot take a legal position which is different than the civilian political appointees of the president. So that if John Yoo says the Geneva Conventions can be circumvented, it would be unlawful for the two-star general for the Army to say, I disagree, I think the Geneva Conventions must be obeyed as a matter of law. And this is a fight that sort of was happening 15 years ago and has been happening much more intensely in the last 5 years. I know we're about to run out of time here. I'd like to say one thing that we haven't gotten to.
Sure.
This has been a very close study of the things that this administration has done to expand executive power, but it's been mostly focused on them and conservative agenda being implemented through this. And I think a critical insight about this is that even though we're having this conversation in the context of a conservative Republican administration, this is above politics. Presidential power is not a partisan issue because the ways in which these precedents and these different trends have all come together to magnify presidential power are for the most part permanent. And that means that when we have a liberal or a Democratic president in the future, perhaps Hillary Clinton just 2 years from now, or whoever it is 10 years from now, 50 years from now, those presidents will also enjoy this arsenal of enhanced, concentrated, unchecked unilateral authority that have been developed and pioneered by this administration. And that's why it's sort of in the interest of everyone, regardless of their politics or their party affiliation, to understand how American-style democracy, checks and balances, the prevention of concentrated government power is undergoing a change right now that is going to have an impact 5 years from now, 20 years from now, 50 years from now. And that's, this book has been endorsed by some very conservative thinkers, George Will, Mickey Edwards, the former Republican congressman and chairman of the American Conservative Union, and others. And the reason for that is that it doesn't matter if you think that we should pull out of Iraq tomorrow or stay forever, if you think the environment's more important than the economy or vice versa. It goes to the structural issues of how we as a society decide what we are going to do, what limits or not limits we're going to have, what rules we're going to have, and how we make decisions as a government about what's going to happen. What's been happening the last 6 or 7 years is going to be still resonating for generations.
Well, I'm glad you brought that up because you relieved me of the necessity to ask the question about it. You know, Charlie, somebody my age, I'll be 70 in 2 years. I was just a kid when Truman, I was not even 11 yet, when Truman went into Korea. Nobody thought much about this until Vietnam came along. And then because of what happened in Vietnam, there have been some of us, and I've had others on my program, Jules Lobel and others, who've been concerned about this through thick and thin for 40 years, through Republican administrations and Democrat administrations. And one finds that at the end of the day, nothing beneficial has happened. That this problem has been with us since Truman. It got far worse under Johnson and Nixon, one from each party. It got far worse again under the second George Bush. And I know maybe you would respond to Jack Goldsmith, because you and he seem to have diametrically opposite views of what all this means for the future. You are pessimistic. He is optimistic, saying that so much has been exposed that is so terrible that this will not be permitted to happen again. A point of view which, after Nixon and Watergate in the 70s, is not intrinsically appealing as being right. But what is your view vis-a-vis Jack Goldsmith?
Right. Well, this is the one area of really substantive disagreement that Jack and I have. His argument is, as you say, that presidential power will be diminished because they overreached and they prompted a backlash. And I think that he's correct in the very small, the short term. If there's another national security crisis, Congress is going to be less willing to pass a very open-ended, no strings attached authorization to use military force, for example. But I think over the long term, at least if you look back through history, what you see is that presidential power has acted like a one-way ratchet. It's much easier to increase than it is to roll back again. And the Nixon example is a great one. You know, there was a few years there of a backlash in which, and this is the years in which that still to this day, and infuriate Cheney and have been driving much of this. But in fact, most of those reforms had already eroded away, even by the end of the Clinton administration. Because new people come to power, new issues arise, the old backlash fades, but the precedents are still there. And so the dynamics of a president who's able to say, I can bypass a law or a treaty because it's been done before, and that shows that presidents can do that. Or I can cite these court rulings that say that I don't need to obey really the Federal Advisory Committee Act, or I can evoke executive privilege in a much broader way now than I used to be able to because of the aggressive and successful work of the Bush administration will still be with us. They are part of our history now, and therefore I think that that's why I say this has been the most successfully implemented policy of this administration. It's unclear to me really that they've made many mistakes at all, and I think that they've succeeded.
Charlie, we have about 20 seconds left. It is my position that one of the major reasons they could succeed was the lack of courage and ineptitude of the Congress. And this Congress was a one-party Republican Congress. The same thing happened under a one-party Democrat Congress in the 60s under Lyndon Johnson. And the courts do not step in forcefully. Don't the Congress and the courts, and particularly the Congress, don't they bear significant responsibility for the problem by their refusal to curb the executive?
Certainly the Congress went easy on oversight and did not strongly criticize or push back against the White House in the last 6 or 7 years. And one-party control of government is a big part of that. Another big part of that is obviously the sense of national security crisis and the fear that accompanied the war on terrorism. These two things operated together to make sure that there was no countervailing force at the very moment in which an administration, much stronger than most presidents usually do, was systematically trying to expand executive power as an end to itself. Yeah. And so that's how the ball has been moved so far down the field. Yeah.
Charlie, thank you very much. The book is an extraordinarily valuable contribution to the American body politic. I think when we were talking earlier on before the program, you said you hope a lot of people would read it, and I think my reaction was, I don't know whether a lot of people will, but a lot of people should. And I think that's eminently true. So thank you very much for the book, and thank you very much for being here.
Thanks for having me on.
And best of luck. And to our audience out there in the world of television, thank you for being with us, and be with us again next time for the next installment of Books of Our Time.
The Massachusetts School of Law at Andover offers an accessible, affordable legal education to both full-time and part-time law students. When making admissions decisions, MS Law looks at all aspects of a candidate's qualifications and does not consider the flawed LSAT. At a tuition of less than half of all the other law schools in New England, it is by far the most affordable. Our teaching and standards are rigorous. Our students learn to think clearly, to write well, and to advocate effectively for others. Decide today to make a difference.
In its first two cases?
Well, the first case was in 2004 when the court held, as I mentioned in the last hour, that despite the administration's legal theories, it did have jurisdiction to hear claims arising out of Guantanamo. And that unleashed a torrent of litigation of habeas corpus petitions on behalf of hundreds and hundreds of detainees who wanted to have some judge review the basis of their detention. Are they really who the executive branch says they are? Are they really Al-Qaeda? Were they just in the wrong place in the wrong time? Are they really Taliban? Or were they just sold for the bounties we were collecting from local tribes that just wanted the $5,000 a head and they shouldn't be in prison anymore? So very few people got released as a result of that. No one, in fact, has gotten a hearing. But it did allow some attorneys to go down and to meet with these detainees and to hear what they had to say and then to relay some of those things after they were cleared to the public. And so it kind of cracked open a little bit of the secrecy of what was happening at that prison. We started learning about things like hunger strikes and suicide attempts and so forth. In 2006, one of those claims that was not a habeas corpus petition, but was actually a challenge to the military commissions, which were finally starting to get underway down there, resulted in the Supreme Court striking down Bush's claim that he could put on military commissions in defiance of a certain statute passed by Congress, or in a different way than the statute said these things had to work, and as a side effect also that he didn't need to obey the Geneva Conventions. And that case, which is called the Hamdan decision, was the single greatest setback to the Bush administration's efforts to expand executive power, because they had avoided having a definitive repudiation of their rather aggressive theories for years. They'd sort of claimed this. People said, hey, you can't do that, but there was no forum in which they were definitively be sort of excluded from his own trial and convicted on the basis of factual assertions that he would never have a chance to rebut because he wouldn't know what they were.
Right.
And Congress, on that latter step, did reject what the administration wanted and said no secret evidence. But on the former controversy, they accepted the administration's arguments and said that coercive evidence obtained through coercion could be admitted on a case-by-case basis, subject to the judge's decision.
Yeah. It is my understanding, Charlie, correct this if it's wrong, that the case that's currently in the Supreme Court now, which it took semi-belatedly, I gather, in certain peculiar ways, involves the question whether it's constitutional to remove habeas corpus jurisdiction. And part of that question revolves around whether some alternative methodology of decision-making is provided for, an alternative satisfactory methodology is provided for. And curiously enough, if I just read the brief filed by Arlen Specter, of all people, saying that it's impermissible to take away habeas corpus jurisdiction and talking a lot about why the procedures are not sufficient down in Guantanamo. He sort of was one of the people responsible for ramming the whole bill through the Congress in the first place, and here he is attacking it, an important part of it, in the Supreme Court. That's background to my question. The question is, do you, and I know this involves speculation, which you don't like to do, but based on what you've said in your book, let me put it that way. I'll make a statement. You can tell me if this statement is really too far off base. I think that given the fact that, that George Bush has put Sam Alito and John Roberts on the court, and that they spent considerable time in their
repudiated, and so they were taking actions based on these claims, and the actions were setting historical precedents which seemed to shore up their theories. Something, yes, it can be done because look, we just did it, so that was doable. But in the Hamdan case, the Supreme Court said, no, you've got to obey a law passed by Congress, and you've got to obey the Geneva Conventions, at least Common Article 3, which guarantee fair trials. And so that was a big deal. And it was sort of, for the people who are critics of the Bush administration's legal theories, it was sort of hailed as, well, now normalcy has returned. It's been, it's been shown that they're wrong, and as we thought. But I think that some factors about that celebration have been short-sighted. One of them is that because of one-party rule in Congress, the administration was very quickly able to roll back that decision on a specific grounds by, in fact, Congress has set military commissions back up for them. But more importantly, Congress, in that same law, the Military Commissions Act, made sure that the decision would never spread, that precedent could not be used to attack any of the other things the administration was doing, so that it was be narrowed. They took away, at that point, the habeas corpus rights of detainees, so there could be no more lawsuits, and they took away separately the jurisdiction of the courts to hear lawsuits that invoked the Geneva Conventions. And so that meant that no one could ever in the future say, hey, wait a minute, you're violating the Geneva Conventions. Essentially, the president could interpret them for himself and into meaninglessness.
Didn't they also, do I recollect correctly, that they also said that the military commissions can use secret evidence or evidence obtained through coercion if the judge at the tribunal believes that the evidence is
reliable.
Reliable.
There were two fights. The Bush administration wanted to be able to use hearsay evidence and evidence obtained from coercion, and it also wanted to be able to use secret evidence, evidence that the defendant would not be exposed to. It could be
Welcome to Books of Our Time, produced by the Massachusetts School of Law and seen nationwide. Today we shall discuss a book by Charlie Savage, the Boston Globe reporter who won a Pulitzer Prize for his reporting on George Bush's use of signing statements. Charlie has vastly expanded his work on executive power for a new book that details the entire gamut of ways that the executive branch has attempted in the last 6 years to extensively destroy the independent authority of Congress and the courts, thus creating, in my personal judgment, by far the gravest constitutional crisis since Vietnam and Watergate. Charlie's new book is called Takeover. Its subtitle, appropriately enough, is The Return of the Imperial Presidency and the Subversion of American Democracy. I believe this book will be the Bible about what has happened until historians begin to fully plumb the actions of today's executive branch 10 or 20 years from now, when memoirs and papers and other such historical materials are more fully available. And while one never knows about these things, my view nonetheless is that Charlie ought to win another Pulitzer for Takeover. It is a great contribution to knowledge of what happens in American government. Charlie Savage is with me today to discuss his book, and I am Lawrence R. Velvel, the Dean of the Massachusetts School of Law. Charlie, to take up where we left off at the end of the last hour, the Supreme Court has decided 2 cases involving Guantanamo. There is a 3rd case up there now. Has the Supreme Court accomplished any younger years in the Reagan administration trying to find ways to extend extensively presidential power? Alito was on a special litigation working group. Roberts wrote some memoranda, and some other things happened when they were up for the Supreme Court, which I can get into later. But I think personally there's no chance, or virtually no chance, I will say no chance, that the Supreme Court is going to strike down what Congress did in 2006 or 2007, whenever it was, with these 2 gentlemen now on the court. Alito voted with the executive the last time. Roberts had to disqualify himself because the opinion being appealed from was one in which he had participated as a Court of Appeals judge. But anyhow, there's my background statement. What do you think about all that?
Well, part of this folds out from what we were discussing just a minute ago. I think another way in which the Hamdan decision has been overhailed by people who are critics of the administration's legal theory is that they fail to appreciate that only 5 of the 9 justices disagreed with the White House in that military commissions case. And the other 4, Alito, Thomas, Scalia at the Supreme Court level, and John Roberts had already done so, as you just said, at the appeals court level, had in fact embraced the theory that the president didn't need to worry about a statute from Congress or the Geneva Conventions in this sort of national security area. And crucially, the 4 are more than 12 years younger on average than the 5. And so I think that if not this president, an election cycle 2 or 2 from now, there's going to be a very good chance that if another president wants to expand his institution's powers, a 5th presidentialist lawyer may very well become a 5th Supreme Court justice. And at that point, the law shifts.
Yeah.
They're right.
Yeah.
Because the Supreme Court, 5 justices on the Supreme Court say something is the law, it is the law. So that's...
We're not right because, how did Jackson say it? We are not